Welcome to our podcast. It's brought to you by the Touro Law Review and the Touro University Jacob D. Fuchsberg Law Center. Our guest today is Professor Gabriel Weil. He's going to talk with us about using tort law as a tool to mitigate catastrophic AI risks. He's done some fascinating thinking and research and writing in this area, so we certainly look forward to it. Professor Weil, welcome.
Thanks for having me, Peter, and thanks to the Law Review for hosting this.
Yes, and I thank the Law Review as well, and thank you for being here. We do have a student audience, of course, and they're always interested in the career path and what brought you to the point that you're at today. So please share with us a little bit about your background.
Sure. So most of my background is in climate change law and policy. I went to law school at Georgetown, and then I did climate policy work for about a decade in DC, most recently at the Climate Leadership Council, which is a think tank and advocacy organization that's supporting a carbon fee and dividend proposal. And so a lot of my thinking is informed by, an economic analysis of the law. Carbon tax is consistent with that. And as we'll see in this conversation, I'm applying a similar lens to AI risk.
So would you say that your background, you're sort of using by analogy, the disciplines that you've studied and focused on in the past, you're now using by analogy? Is that fair or?
Yeah, I think that's fair.
Okay, so good. I mean, it's always nice to put things to new creative uses. So let's turn to our topic about using tort law in this context. And one question would be, why do you believe that tort law is a good or even the best governance instrument for mitigating the risk posed by advances in AI, artificial intelligence?
Okay, so there's a few different angles you can take on that question. So one is to think about, is AI risk a policy or a problem for law or policy at all? So you might think this is just a technical problem that engineers need to work to figure out how to make these systems safe. And on some level, that's true. But the reason I think it's also a policy problem, bringing it back to the law and economics conversation, is that the people who are building and deploying these systems don't bear all the risks that are generated by the activity. And neither do their customers. So some of the risks that they're generating are to third parties who have no choice in the matter. And so economists would call that a negative externality. And if you read an Econ 101 textbook, what it will tell you is that activities that produce negative externalities tend to be engaged in too much from a socially efficient perspective or socially optimal perspective. That because people don't bear those costs because they're able to what economists call externalize those costs, they do too much of it. So you might drive your car too much because it creates pollution and you're not responsible for paying for that pollution. And so, that's the same principle that drives the idea behind, say, a carbon tax. That you drive your car or you run your air conditioner, and that produces some extra CO2 to generate the electricity, or when your internal combustion engine burns the gasoline, and those harms are felt by people all over the world. And so you don't have an incentive to consider that necessarily. But if we tax the carbon content of your fuel or the carbon emissions that were associated with generating the electricity that you use to run your air conditioner, then you're going to have an incentive to do less of that. And so the same principle applies to AI risk, that what we should be trying to do is make the people and the companies that are generating these risks bear them. But why use tort law instead of something like a tax? And there's really two reasons for that. So one is that with climate change, we know the magnitude of the externality, at least roughly, at the time you engage in the activity. So we can measure how much carbon you put into the atmosphere. And we can decide, well, for any given ton of carbon, we're going to charge you, say, $50. Whereas for AI risk, it's much harder to know what the risks generated by any particular activity are. It's much harder to measure. There's not some measurable output like carbon emissions. By contrast, if you were to try to use a liability regime for climate change, that would be really difficult because it's hard to trace any particular climate harm or any particular climate impact to any particular ton of emissions. And so you can't really even say that a big company like Exxon is responsible for someone's house being flooded in a hurricane, right? You don't know whether the incremental emissions that they're responsible for were what was necessary to cause that. It's basically impossible to attribute and prove that. Even if you could say that a particular storm which was caused by climate change at all, which is hard for scientists to do. They're working on trying to do that. It'd be much harder to say that Exxon's particular emissions are responsible for it. By contrast, in the AI context, I think you can say that a particular system that someone trained and deployed, someone put out into the world, was what was responsible for someone's injury. And so it's a lot easier after the fact to say, well, you should pay for the harm you caused.
If I may interrupt
Yeah.
just for a second. Uh, and so, forgive the sort of the naivete of this question, but are there examples of AI risks that can be attributed to a particular AI development and deployment? Like, are there any specific examples?
So if you mean harms that have actually happened,
Yes, I
I
think
think
that's
those
what.
are non-catastrophic harms, right? But people are subject to algorithmic bias. There's autonomous vehicles that malfunction. Those are mostly what I would call capabilities failures. So the system isn't performing as well as we'd like it to, or as well as maybe it has the right goals, but it's just not that good at achieving them. The risks that I'm most concerned about are actually what you might call alignment failures or misuse, where the system might be very capable, but it might be trying to achieve a goal that's different than what its programmers were trying to put into it, or the people who are using it might have bad intentions. They might be misusing it to cause harm. And as systems become more powerful, right now with GPT-4 level systems, we might not be so worried about that, because even if the system has bad goals or the people using it have bad goals, the system just isn't that powerful enough to do anything that bad. And so we're mostly seeing these capabilities failures. But in the future, those are probably going to become less prevalent as these systems get more powerful, and the risk from misalignment or misuse is going to get bigger.
Okay. So okay, that makes a lot of sense. I mean, I guess if it's a systems failure, tort law has handled those for a while, but you're now branching into, or not branching into, building into, I guess, something much more significant, and even as you say, the term catastrophic. So we're both sort of tort guys here, and we know that there's intentional torts and negligence torts and strict liability torts. So, which theory of liability do you see as most useful as a tool of regulating these catastrophic risks?
Yeah, so I want to get to that question, but I just want to make one other point
Of
about why
course.
liability in the first place,
Okay.
which is that there is significant orders of magnitude, even social disagreement about how big these risks are. So some people think AI is very likely to cause literal human extinction this century, and other people think that risk is totally fake and close to zero. And so if you're talking about what instrument you want to regulate a risk like that, the main alternatives to liability are prescriptive regulation, an agency setting out rules that AI companies have to follow, or what's called approval regulation. Like we have the FDA approves new drugs, and you could have AI systems submitted to some agency like that before they're allowed to deploy them. Both of those require a strong consensus that is at least roughly truth tracking ex ante about the magnitude of the risk, because you need to know how stringent to make the prescriptive regulations or the approval regime. And I think that's very hard given the uncertainty we have about these risks. Also, the people who are most expert about the risk and how to mitigate them are not in government. They're in the lab. That's where all the top talent is. And so it makes sense to shift the onus to the companies that are building the system to figure out how to make them safe. And that's what liability, at least in theory, can do. And so that gets to your question about what theory of liability. And so the kind of liability that's clearly available under current law is negligence. And so, as students who have taken torts will know, there's a few things you have to prove in a negligence case. The most important in this context are breach, factual cause, and proximate cause. And so for a breach and factual cause, I think are worth addressing together. And so to establish those in combination, you have to show that there's some precautionary measure that a reasonable person would have taken and the defendant failed to take that precautionary measure. And had they taken it, it would have prevented the plaintiff's injury. And I think that's going to be difficult to show in a lot of cases, a lot of the sort of AI risks we're worried about, because AI safety and alignment are unsolved technical problems. And so there's not going to be some off-the-shelf technique that you can point to in a lot of cases that if they had just implemented it, and you can show, well, obviously a reasonable AI developer would have done that, and they didn't, and that's why this injury happened. It might be that you do all the basic things that ordinary reasonable AI developers do, and that's inadequate. And that's in part because the breach of duty inquiry in a typical negligence case tends to be pretty narrow. So if I run over a pedestrian with my car, the court doesn't ask questions like, was this car trip reasonable? Were the benefits of me taking this trip instead of walking large enough, or instead of staying home, large enough to justify the risk to pedestrians? It also doesn't ask questions like, say I was driving an SUV. Should I have been driving a smaller car? Were the benefits to me of driving this SUV, of looking cool, of having the ability to take more passengers or more cargo, did those justify the risks? Instead, they ask questions like, was I drunk? Was I speeding? Was I texting? And so they assume that the negligence inquiry typically doesn't examine whether the activity in general is worth doing. And so the reason that's important in the AI risk context is if we're engaged in a negligence inquiry, I don't think courts are going to ask, should you have been building this this advanced system on these broad parameters that you didn't fully understand? That's not an inquiry that fits well into a negligence analysis, but it does fit pretty well into another doctrine that's available under tort law, which is strict liability on an abnormally dangerous activities theory. So you might recall from your torts class that if you are blasting with dynamite and someone is hit by rubble from the dynamite blast, it doesn't matter whether the defendant was exercising reasonable care if the activity is abnormally dangerous, meaning it's an activity that's not in common use and still creates a large risk of harm, even when reasonable care is exercised, then the defendant could be held liable regardless of the degree of care they exercise, so long as the harm arises from the inherently dangerous nature of that activity. So if someone trips over a piece of rubble from a dynamite blast, maybe maybe strict liability wouldn't apply there, because that's not necessarily related to what makes dynamite blasting inherently dangerous. Whereas if they're hit by a flying chunk of rubble, that is going to be related. And so what makes frontier AI development abnormally dangerous is that these companies are building these powerful systems with impressive capabilities that we don't fully understand ex ante, and they're very difficult to control. We don't know how to make sure that the systems will do what we want them to. And so even if you do all the ordinary reasonable things, that might not give us sufficient protection against the risk. And so we might think that we should apply strict liability and say, if harms arise from that inherently dangerous nature, and again, those are probably going to be type of harms that I would call alignment failures or misuse. I think capabilities failures can mostly be handled by negligence law.
So, of course, this is very interesting to me as a torts professor, and two things occur to me. First of all, is there any relevance of strict product liability? I mean, because they say they pay lip service to the risk utility test, but of course they only ever focus on risk. About the only time they ever focus on utility is for prescription drugs. Otherwise, it's mostly a risk analysis, as I guess a lawyer would conceive it. So abnormally dangerous activity is one kind of strict liability. Is there anything to be gained from the product liability aspect to the extent
Sure.
it's done?
So this is also something I analyzed in the paper. So there's a few different issues that arise with products liability. So first of all, there's a threshold question of whether the regime is even applicable. That would depend on whether these AI systems are classified as products as opposed to services, and that's going to be a context-dependent inquiry. Certainly, if you're open sourcing a model, you're not charging for it, then you won't be a commercial seller, and the products liability regime won't apply. But also in other contexts, it might be classified as a service, and so that regime wouldn't apply. Second, let's assume we're in the products liability game. And then the question is, does this provide adequate protection? So as you know, Peter, there's three different kinds of product defects. there's design defects, there's warning defects, and there's manufacturing defects. Manufacturing defects is the closest to a truly strict test,
Mhm.
a truly strict liability standard, where even if your quality control process is reasonable, if an individual unit of the product comes off the line, deviating from its specifications in a way that makes it unsafe, then you could be held liable. But there isn't really much prospect for a manufacturing defect in the software context. Not even clear what that would mean. You ship an instance of the software that has a coding error or something. You copied it wrong. That's not something we're really worried about. Instead, we're mostly talking about with AI design defects. And the test for design defects is much more negligence-like. It's was there some reasonable alternative design? And by reasonable, we mean was there some design that wouldn't have been significantly more expensive or wouldn't have been too much more expensive and wouldn't have sacrificed too much more on other features of performance or product quality that would have prevented this injury. And again, because AI safety and alignment are unsolved technical problems, I think it's going to be hard to point to some reasonable alternative design that would satisfy that test.
So plus you probably couldn't find the experts anyway because they're all in the lab as you said earlier. But you certainly make a point that's of interest to our tort students in that the risk utility test, many commentators feel, well, you know what, that's really negligence. So we can call it strict liability, but we're pushing it back into negligence. You use a term that I find very interesting, is the regime applicable? And is there any challenge in the abnormally dangerous activity regime that might, well, a challenge in making that regime applicable to AI?
Right. So I would say by default, that is not applicable, right? So a
By
court would
default, I'm
have,
sorry.
sorry, by default, the abnormally dangerous activities regime is not going to be applicable to AI. I think that would be a small doctrinal innovation for
Okay.
courts to extend the abnormally dangerous activities doctrine to AI. If you look at the sort of meta doctrine of abnormally dangerous activities, if you look at, say, the third restatement, and you look at the factors for whether an activity counts as abnormally dangerous, I think if you have the understanding of AI risk that I do, it's pretty clear that AI development, at least for these frontier systems that are poorly understood, should fall under that. But I think it would take a small doctrinal innovation for courts to actually make that move. And I think it's going to seem weird to a lot of state Supreme Court justices to say that some kinds of software development are abnormally dangerous. It's not going to be intuitive to them that that's abnormally dangerous in the same way that blasting with dynamite or keeping a pet tiger, to use a different example, seems abnormally dangerous.
I find that very interesting as well. And I think that's where people like you are doing some of the most interesting thinking because we are going to have to make some doctrinal adjustments. And I think about opiates and trying to call that a public nuisance, which we as tort professors know, gee, that's not the first thing I'm going to think of if you talk about a public nuisance. But I mean, there was a recovery by a state court that applied that doctrine. And so it's a doctrinal challenge, but it sounds like it could be met. And it sounds like you know, the first thing to do is to recognize it. And then the second thing to do is to make the arguments and justifications for making the change. So I'm sure your papers, which, but at the end of the podcast, you could help us all find exactly where they are. I'm sure that's very interesting. Uh, these do sound like some pretty large risks. So, I mean, do you envision some kind of lawsuit to enforce damages as they occur? I mean, how would you ultimately translate that into a remedy?
Yeah, okay. So a few different points to make there. First, just one final point on the strict liability versus negligence.
Okay.
There's the sort of judicial pathway where litigants could bring these cases and argue that courts should apply the abnormally dangerous activities doctrine to frontier AI development. You could also imagine legislation on the state level to apply strict liability on abnormally dangerous activities like theory, but without courts having to get there on their own.
Okay.
In terms of the way damages should work, if the harms are small enough that that the plaintiff or the defendant can afford to pay a compensatory damage award, then the ordinary kind of damages, compensatory damages, work just fine. And so for sort of medium-sized risks or small catastrophes, I think that would work just fine. These are pretty big companies. They're worth billions of dollars. They can pay out, say, $1 billion damage award. But beyond that, it's good. There's this problem that obviously, if we're talking about literal human extinction, no one's going to bring a lawsuit if that happens, right? But even well short of that, you could imagine worlds where the legal system's no longer functioning because society is sufficiently disrupted, or it's just a financially uninsurable risk. So if your system is responsible for the death of 1 million people or the destruction of $500 billion worth of property, then no company is going to be able to pay that without going bankrupt, and it doesn't even seem like any insurance policy could plausibly cover that. And so going back to the sort of law and economics of this, if you're a company that's generating those risks and you know that if they're realized, you won't actually have to pay for the full value because it's impossible to enforce that against you, then you're not going to have adequate incentive to account for those risks. And so what can we do about that? Can tort law do anything? And most people tend to think the answer is no, but I think there is an answer. And that answer is punitive damages. So compensatory damages, as students know, aren't the only kind of damages that are available in tort cases. We can also have damages over and above the value of the injury suffered by the plaintiff that are designed to punish the defendant. And so in theory, what we could do is say, if your system harms someone, and that's a harm that's small enough to be practically compensable, that you can enforce a compensatory damage award. But it does so in a way that suggests it could have gone a lot worse, that suggests that deploying the system generated uninsurable risks. Then the plaintiff should be able to recover not just for the harm they actually suffered, but also for the uninsurable risks that were generated by the deployment of that system. But I want to say there's a couple important barriers here. So one is that long-standing punitive damages doctrine requires that the defendant have acted with malice or recklessness. And so as we talked about, I don't even think ordinary negligence is going to be easy to prove in a lot of these cases. And malice or recklessness is a much higher standard. It's even higher than gross negligence. And so at least under existing law, punitive damages are not generally going to be available. There's also no real precedent for basing punitive damages on this sort of speculative counterfactual harm. So usually with punitive damages, the idea is there's certain types of harms where someone's unlikely to sue or something like that, or we just think the conduct is so reprehensible that we want to send a message. There's not really any precedent for saying, well, the system did some harm, but it could have gone a lot worse, and we're going to charge you for that because we won't be able to charge you if it actually happens. Nonetheless, if you look at at least the law and economics version of the normative rationale for punitive damages, which I see as the most compelling normative rationale, it's that compensatory damages would underdeter the underlying tortious activity. And that's exactly what these punitive damages would be doing. They'd be solving that problem and stepping in to provide deterrence value because we can't apply compensatory damages if uninsurable risks are actually realized. But I do think courts are pretty unlikely to take this step on their own. It would be unlike the extending the abnormally dangerous activities doctrine to AI development. This would be a substantial doctrinal change that probably couldn't be limited to the AI context. So it would be overturning long-standing doctrine and doing it in a way that would tend to have a pretty broad effect. I think courts are pretty unlikely to do that just because I tell them they should. And so it's probably going to require legislation to make that kind of change.
Okay. So I guess that raises two questions. Perhaps you've actually answered both of them, but you did mention several times about liability and insurable risk. Is there literally a role for an insurance policy here, which seems to underlie so much of our tort law, probably drives it in the US, certainly. Is there a policy that can be written?
Right. So obviously there are some risks that are going to be uninsurable, but there are other risks that are large enough that a defendant might be judgment proof if they didn't have insurance, but that insurance could extend the universe of what I call practically compensable harms that you could enforce a compensatory damage award. So maybe you can have a $10 billion insurance policy. And even though they would only be able to pay out $1 billion if they didn't have insurance, then you've increased the range of practically compensable harms to be much larger. That's one benefit of having a mandatory insurance requirement, that you would need to lean less on punitive damages, that for harms that are between what a defendant would otherwise be judgment proof for and the maximum insurable risk, the insurance would step in. That's one benefit. The other is that some of these AI companies are more concerned about AI risk, about the catastrophic risks from their systems than others. So if you talk to the leaders of, say, Anthropic, they're pretty worried about this. They're being relatively careful, maybe not as careful as I'd like them to be, but they take these risks seriously. If they expected to be subject to strict liability and punitive damages, I think their behavior would change a lot. On the other hand, the leaders of a company like Meta, so if you look at what, say, Mark Zuckerberg or Yann LeCun, who's the chief AI scientist at Meta, they're pretty dismissive of these risks. And so if they don't believe the risks are real, maybe they won't adequately account for them, even if they expect to pay out for harms that they actually do cause. And so liability insurance would introduce a more cautious decision maker into the loop. You would have to convince the insurance company to write you a policy you can afford, or you'd have to convince your investors to provide you with enough capital to self-insure. And so they're going to, as part of that underwriting process or as part of that investment process, they're going to want to scrutinize your liability exposure. And it's not going to matter if Yann LeCun doesn't think the risks are real. If the more cautious insurance adjuster thinks or the insurance underwriter thinks that the risks are real, that's going to put a brake on that process.
Well, I think one interesting thing is that you began your discussion by talking about there's not agreement as to whether these catastrophic risks will ever materialize. That seems to be percolating underneath a lot of what you're talking about, and it's sort of really a little bit of a geyser here where it's come above the surface. Like, gee, if I don't think I'm creating any risk, what do I need insurance for? So that's certainly another interesting aspect. But you talk about mandatory insurance, which I guess leads to my next question. So there are other tools besides tort law, like mandatory insurance, I assume would be legislatively mandated, which suggests that besides tort law, there are other governance tools that can be useful in this sort of regulation. Is that correct?
Yeah, so I certainly think mandatory liability insurance. I think of that as part of the overall tort framework, but I agree that's not something that can be done by courts, and it's not liability qua liability. It's sort of a supportive instrument.
Mm-hmm.
But there's also regulatory instruments totally outside of liability that I think are warranted. And so one way you can look at this is as what problems liability solves, even sort of the maximalist ideal liability regime that I'm proposing with strict liability and liability insurance requirements and punitive damages for uninsurable risk. Even that framework, there's some problems it can't solve. So I can go through a couple of those. So one you might be worried about is these catastrophic uninsurable risks. My framework only works if you think that what you might call as warning shots or near miss cases are substantially more likely than actual catastrophes. If they're not, then you can't use this sort of indirect liability to internalize those risks. And so if you're not expecting, say, 50, 100 of these warning shots for every actual catastrophe, then you can't say there's only like 3 warning shots on average per catastrophe, right? Well, then you could only internalize a risk 3 times above the insurable limit, right? And so if we're talking about extinction level risks, they might just be too big, or there might not be enough warning shots to address those using the prospect of tort liability. And if that's true, then you might need some other regulatory intervention to address those risks. And that could be some combination of prescriptive rules and approval regulation. So in my ideal framework, I think you'd have something like a regulator would have mostly their job would be to decide what the maximum harm that the system could cause is and to set the liability insurance requirement. But they could also have the ability to say, well, if we can prove to a court that your system generates large enough uninsurable risk and is unlikely to generate warning shots or near miss cases, such that we can prove by preponderance of the evidence, say that uh, that the prospect of liability is going to be inadequate to get you to account for those risks, then maybe they could just bar you from deploying the system or only let you deploy it in certain ways under certain conditions. The reason I think they should have to prove that to a court is that I think a regulator that's empowered to disapprove deployment of these models might get a little trigger happy with that. If you look at the way the actual FDA works, a lot of people who examine that think that they are too eager to disapprove drugs, right, and too eager to impose new conditions on that. And I think if we want to be balancing the risks and the benefits of this technology, we want to be primarily relying on this ex post liability as our governance tool. It's only when that tool breaks down that we want to bring in other instruments. The other thing I would say is, we talked about this externality market failure, but maybe there's other market failures with AI development. So you might think that there's another kind of market failure called a public good. A public good is something that's non-rival and non-excludable. And economists will tell you those tend to be underprovided. And so maybe alignment and safety research is a public good, and maybe we need to subsidize that. And so tort law wouldn't address an issue like that. And finally, this is a global problem. And so you might need some sort of international coordination. You could possibly do some of that by reciprocal treaties that get countries to enforce each other's tort judgments. But there's probably some other kind of international coordination you're going to want to address the sort of national security aspects of this. Governments in particular are unlikely to be deterred in their uses of AI by the prospect of liability. And so we probably need other legal and policy instruments to address risks like that.
Well, it is interesting that you turn to sort of the global aspect of this. I mean, you mentioned the FDA, and some people say they're too slow. Some actually say they're too fast, but many say they're too slow. And then you could compare that with literally other countries, other governments, and usually they have those drugs approved faster than they get approved in the US. I mean, there are people who go, as you know, outside the country for certain drug treatments. There's always a question as to what system is best. So I guess this global phenomena does pose a real challenge in trying to coordinate nations with different views of not only tort law, but so much else. And so you do think that treaties, conventions are maybe the best way of trying to do that?
Yeah. So if you compare this to climate change, that's another global problem, right? And we've struggled to achieve the level of global cooperation because carbon emissions are this global externality. In some ways, it should be easier to coordinate on AI because a smaller number of countries are involved in developing it. And the harms, at least the systems are more likely to be deployed in the countries where they're developed for language and other reasons. And so in theory, this should be an easier coordination problem. But when you look at the most straightforward step of getting countries to enforce each other's tort judgments, the U.S. currently has 0 of these treaties with other countries. U.S. courts often, as a matter of comedy, do enforce other countries' tort judgments. But when you look at the state of the U.S.-China relationship, this is probably the most important bilateral relationship when it comes to AI. These are the countries that are the 2 countries that are most involved in AI development. It seems unlikely that the US and China are going to negotiate this kind of treaty, both because of the level of animosity in the relationship, the difficulty in seeing eye to eye on anything, the rhetoric, the hostile rhetoric about China in domestic US politics makes that seem like an unlikely outcome, and because there's so many other issues on the agenda that this one doesn't seem like it's going to be prioritized. And so I'm not super optimistic about what that treaty process is going to look like, but I do think it's going to be important in the coming years. And hopefully, as we see some of these risks start to emerge and AI governance rises on the global governance agenda, that will get more attention.
Well, I think maybe the only hope we have is that there's such an economic benefit to both the US and China to actually negotiate on this area. So maybe your law and economics can kick back in and somehow find some common ground where both countries can benefit significantly again.
My fear is that both the US and China are going to view this issue primarily as one of geopolitical competition, and having the most powerful AI systems being the key to global domination in the future. And they're going to be not viewing it mostly in a cooperative mindset. And I think that that's going to be a significant source of risk in the coming years.
Yeah, I mean, if each individual self-interest doesn't drive it to the negotiating table, I guess there's not much hope. Um, as always, you have the last word. Is there any aspect of this that you'd like to talk about or summarize or emphasize? Because we certainly have time for you to do that.
Sure. So one other thought, when I was talking about the role of other policies, I was assuming that we had the maximalist liability framework. And so
Okay.
something I'm working on in my current project is, well, right now the existing liability regime is not so great, right? You don't actually get that much risk mitigation out of a negligence regime. Maybe that gets the lagging labs, the metas of the world to behave more like the Anthropics or the DeepMinds. Um, uh, but it doesn't do what you want from strict liability, which is giving all these AI developers an incentive to push forward the frontier on safety, to be thinking of new ways to make their system safe that the ordinary reasonable person standard wouldn't require, or that regulators wouldn't necessarily think of. But by default, we don't have that strict liability regime, and we don't have punitive damages widely available, and we don't have liability insurance requirements. So you have a relatively weak incentive that only applies to risks for which the defendants wouldn't be judgment proof, and only provides protection up to the reasonable care standard through the relatively narrow lens that tends to be applied in negligence cases. And so given that, I think there's much more scope for other tools to come into play, even though in my view they're not optimal, because it's hard to know, both because regulators are more poorly positioned to write ex ante rules. They're going to anticipate developments in technology. It's harder for them to be nimble and adapt into this fast moving technology. Also, regulators are just more poorly informed and less expert than the scientists in these labs. But still, if tort law isn't going to be up to the job, and you think these risks are real, then we are going to need other tools. And so I think by default, there's more scope for both prescriptive regulation and approval regulation. One other issue that I get into in the current piece I'm working on is how we should think about the potential for preemption of state tort liability regimes in a potential federal AI regulatory bill. A lot of the rumors about what that bill might look like suggest that it would include an express preemption provision that would set aside existing state tort law. And I think it's worth people who are worried about AI safety considering whether that would be a trade worth making. And so maybe you think, okay, the background negligence regime isn't that valuable. Maybe, preempting that isn't such a big deal. It wouldn't be so hard for a regulatory regime to offer more safety than that. But it's also worth considering that if you preempt state tort law, then you're also cutting off the potential future development to include things like strict liability or liability insurance requirements or punitive damages. And so it's hard to estimate how likely those things are to happen. Despite how persuasive my law reviews articles are, right? They haven't yet taken the world by storm in terms of courts adopting this, right? And so maybe if the facts on the ground change, that's going to make those types of developments more likely. But it's hard to both estimate how likely that is and how much risk mitigation you get from getting some of these components and not others, right? So it seems much more likely that you'll get strict liability, since courts can pretty straightforwardly do that as an extension of current doctrine. It seems like a relatively minor legislative step to adopt liability insurance requirements. We have a clear precedent for that from driving. Punitive damages are really the piece that seems least likely to happen, absent some major changes in facts on the ground that convince people these risks are really a big deal and they are potentially catastrophic. And so I think it's worth some quantitative work trying to figure out how much risk mitigation you get without that and how likely those sorts of scenarios are to think about whether it'd be worth accepting a reasonably strong federal regulatory bill that preempted state tort law. That's something I'm thinking about right now.
Well, you certainly convinced me that the tort system needs to play a role. I mean, it can be not particularly focused, could be unfocused, but certainly more nimble. Once the legislation gets passed, good luck amending it and trying to have it somewhat malleable. And we both study these issues where you've got the feds possibly preempting state torts and everything that leads to. You mentioned your current work a couple times, and I know that the editors of the Law Review will help us when they publish a summary of this. But just generally, if you could let our listeners know what they might find if they check the podcast website and find this podcast, where can they find some of this work that you've already published?
Right. So the main piece is up on SSRN. It's called Tort Law as a Tool for Mitigating Catastrophic AI Risk. So that piece isn't out in a law review yet, but it is up on the internet for people who want to read it. I've also written a number of shorter pieces for more popular outlets. So I have two pieces in Lawfare. One is on California's Senate Bill 1047, which created some tweaks to the liability regime, also included some other regulatory provisions for frontier models. That bill was recently vetoed about a week ago by Governor Newsom. But it received a lot of attention over the last few months in California and in the national debate. I also have another piece in Lawfare on making the case that tort law should be the centerpiece of AI governance, responding to another piece that was published in Lawfare arguing for a more modest role for tort law. More recently, I also published a piece in Noema magazine, which is a web magazine that is a shorter, more popularized version of the basic tort law framework that's in the piece that's up on SSRN. And that's all I can remember off the top of my head, but there's a couple other short pieces that we'll link to on the show page.
Well, it's an impressive list. And I certainly want to thank you for appearing. The discussion for the most part was beyond me, but I think maybe our students will have a much better grasp of this context. We have been listening to Professor Gabriel Weil, who teaches here at Touro. He's been talking with us about using tort law as a tool to mitigate catastrophic AI risks. Professor, thank you so much for joining us. And I've been your moderator, Professor Peter Zablotsky, also here at Touro. Gabe, thanks again.
Thanks so much. And just for Touro students, I will be teaching a course on law and artificial intelligence again this spring, so you should feel free to register if you found this content interesting.
So for current and future students,
right,
you'll be teaching that. If you're interested in this area, maybe you might want to come here and take Professor Weil's class. Thank you very much.
Thanks so much.